Good evening to everybody. We start this panel, and the focus of this panel is on the relationship between legitimate interests and purpose limitation. As you know, the traditional approach in regulating data protection that was in the previous directive is partially confirmed and maintained in the GDPR. And in this approach, the focus remains on the purpose for data collection and the purpose that are defined at the moment in which the data are collected. This creates some problems mainly with regards to big data. In big data and IoT, when we collect information, we are not aware of the transformative use, using a term suggested by Homer, Tene, or the transformative use of personal information. Because when we collect information for one purpose, but using analytics suggests you something different in many cases, and so you want to use the same information for different kind of purpose. So purpose limitation, notice and consent are critical in this specific context. And moreover, when we talk about the use and application of big data and IoT, we don't focus only on the individual dimension, but even more is more and more important the collective dimension, because these data are used to take decisions that affect a large number of persons, in many cases persons that are not specifically selected or known at the beginning of the process. So these are the different criticisms. And also in previous panel, we discussed about this aspect more related to the negative impact to the collective dimension in terms of discrimination, etc. So the main question are, which is the most adequate way to answer to this kind of criticism? So the approach of the panel is, as we call in the traditional continental Europe, is the Jure Condendum approach. So we talk about the future, not about only to the existing framework, and in which way the general and collective interest can be adequately represented and safeguarded, and which is the role that the different actors can play, the companies, the consumer, and the data protection authority, and so on. All this is based on extensive work written by our colleague, Professor Moerel, on this topic. And so I give her the floor because she's in the best position to introduce the more specific topic of this discussion. Thank you.
Okay, thank you. I hope this works. I wrote an extensive paper on this topic together with Corinne Prins. I will give you a very, very brief outline of the main arguments why we think the current system with a purpose limitation is a bit outdated. And I will give the introduction, and then we'll have a number of the statements that are in that paper, and I will repeat here. And then we'll each, I'll give the floor to each and every one of you to discuss, and also, you know, you can participate as well. Summarizing, to be on the same page when we start here, the current system is 5 tests. There must be an explicitly described and lawful purpose, that is purpose specification. Then only data that is relevant for that purpose you are allowed to process, data minimization. There must be a legal basis to process the data, contractual necessity, consent, legitimate interest test. Then, if it's special categories of data, you need a specific legal ground, and if you further process data, it needs to be compatible with the original purpose for which you collected the data. If you look at those tests, the purpose limitation principle is the first and the last test. Those two together are purpose limitation principle. So, why do Corinne and I think it doesn't work? In a very general, as a completely out of the statement, and we think it is supported by research, but there are many instances that data is processed or are processed currently in violation of the laws where it is not enforced, even though a lot of people object to think about, you know, the cross-border tracking on websites with the cookies where everybody clicks for OK. People do not feel comfortable with that. Then, you know, we have the Internet of Things, we have big data, and there are many purposes, also in the public interest, where you feel purpose limitation doesn't fit the bill, while those services or investigations or research have a clear societal value, and the associated risk can be managed and shouldn't be prohibitive. Now I'm going to give you an example, and which is the main element of our paper. Think about an app that actually tracks where you are, who you meet, and whether people are ill, also based on their search behavior. And you can do that if you have the symptoms of the flu. People start looking up on Google. So that commercial app can indicate to you who to avoid the coming days not to become ill. This is not a weird example. It is actually an app that exists. Think about a similar app with the same functionality that actually is used by the World Health Organization to contain a big outbreak of Ebola. It is the same purpose. It is tracking, monitoring, and personal prediction of health and illness. And I do think that a lot of people wouldn't like or would think about, is that allowed? With the first app and the second, they say yes, for Ebola to contain that may be a very good thing. Do you see that the purpose is the same, but the interest is different, and that actually is the differentiating factor whether to how you think and feel about an app. So, a second point, why we think the current system doesn't work, and think with Google Street View in mind. We think the purpose limitation principle is outdated. In the past, data were a byproduct of a service. Think, I book a flight because I want to have a flight to whatever. I fill in certain data, they need that to book the flight. Do they need to ask my faith? No, not relevant for the flight, for booking the flight. Purpose limitation is an objective limiting test to decide what data you are allowed to collect. The moment the purpose of collecting the data is actually the purpose of collecting the data itself and analytics itself, do you see that the test is no longer objectively limiting? It is depending on what you want to do, and then you decide, it's the controller deciding Google Analytics or Google Street View what type of data they want. The moment data analytics is the purpose, the purpose limitation test is no longer objectively limiting. Then I think you should, is there a legitimate interest for Google to actually collect this data? Yeah, I hope you all get it. It's very short, but this is a main point. A third reason why it doesn't work is, think about, I know everything about the cookie laws and the privacy laws. I go online, want the information on the site, I click agree to all cookies, and I hate the cross-tracking. Is this a true expression of my wishes, my choice? No, I don't think it is, and that is why I think consent in these, there's an easy way to abuse the consent principles without not protecting actually the interest, the privacy interest of the individuals. Another reason why it doesn't work. We become more and more visible, except for ourselves. We have no clue what the others know about us, and they do know a lot about us. The whole starting point that if you inform me and that I then know enough to make decisions is, I think, outdated. I think we have to help individuals to make certain decisions and decide what fits in the bucket where there is a legitimate interest to do so and when not. So when there's an actual choice provided to individuals, it's a meaningful choice. We need to have that responsibility, take the hot potato of making those choices should to a large extent be moved to the regulators. Finally, I think finally, the fifth reason why it doesn't work, I think the whole regime for special categories of data is totally outdated, is no longer meaningful. It's totally unclear up front whether data are sensitive or not. You can have a very totally regular data and the inference may be sensitive. And the example here is target. Based on the fact that women change their buying behavior to unscented cosmetics, target could see or derive that you're likely pregnant and started sending, information, commercial information about pregnancy. The point is totally innocent data, purchasing data not of sensitive nature, and still the inference is sensitive. And there are many, many examples to be thought of there. But it's also, you have credit card data, not sensitive, but very big impact on data protection. Passwords. It's often in the combination of elements. If you have a lot of elements, you can make convincing phishing emails. Big impact on the privacy. Doesn't have anything to do with special categories of data, etc. In those cases, I think the legitimate interest test would provide more protection. And I think the Working Party knows that. By saying, because you have the legal basis for processing special categories or data is contractual necessity for an insurance contract and often consent. But then it's a consent to the whole set. If it is a contract, it is allowed. Where's the necessity there? Do you really need the data? Can it be done in another way? And the Working Party says, yes, indeed. It's not sufficient to have a legal basis under Article 8. You also have to, Article 8 can never be a lower protection than Article 7, meaning you need to do the legitimate interest test. And also the Working Party knows that the consent is an empty shell, and they say, look, even if you get consent, then you need to do it in accordance with fair processing principles. It shouldn't be excessive. All elements that are part of the legitimate interest test. So I think applying the regime for special categories of data is not sufficient, and I think the Working Party agrees with me and starts doubling up tests to make it work. And we see that under the GDPR as well. It's still the same system, but in addition we have now the data protection impact assessment for processing large-scale sensitive data, special categories of data. And if you look at the test and the assessment you need to do, it is in fact performing a contextual assessment, which is the legitimate interest test. So, if you process under the GDPR, you tell your people in the business, yeah, you need consent because you under special category of data, you need consent. But on top of that, actually, you have to apply the legitimate interest test. My point is that I think things are getting too complicated. There are too many tests. I think I work a lot with practitioners. I teach them. I see they miss the clue what purpose limitation actually is. I think it is the test in the end, whether it's for compatible use, for a DPA and legitimate interest, are more or less the same. And this is an impossible slide, but I tell you, it is listing all the criteria, and we do it in a good way in the paper, that you have to assess when you check compatible use. It's the test you have to do if you do the legitimate interest test. They're all the same, except of the relationship between the prior purpose, because if it's a legitimate interest, you collect it for the first time. Under the data protection regulation, the compatible use is more or less codified what was set by the Working Party. In the DPIA, again, codifies the same requirements. I think in the end, the outcome of the test will be more or less the same. If something is totally non-compatible, you wouldn't have a legitimate interest, and vice versa. So, this is what later on I will explain what our proposals are to replace the purpose limitation, that is to introduce the legitimate interest test as the test for all phases of the processing. So when you collect the data, when you process it, when you want to delete it, and when you want to use it for other, or combine it, or want to use it for further purposes. But first, I would like to have a discussion with the panel on the first point: does the current system lack legitimacy and effectiveness? I think, Eric, you would kick this discussion off.
Thank you, Lokke.
Yeah?
Yeah, I agree on the complexity. And I want to tell a little bit of my own history, is that I started 4 or 5 years in the big data arena. And I encountered pirate islands, what I called. When I start looking at large corporations, I saw departments that were very enthusiastic about the new technology and start collecting as much data they could get and doing creative stuff with it. And normally C-level didn't even know about it. So not a lot of purpose specification and purpose limitation there. Now, 4 or 5 years later, we learned from that, and we see that 90% of the work is actually getting and cleaning the data. So you should organize yourself and to find the right data. So what you see is that it's very complex to analyze in advance what the data is you will need. And what you see now is happening, that we shift from recognition from numeric data to text data to image data, and these getting far richer in information. And to know in advance what data you will use is very difficult. And so the risk that you run as a company is that you are forbidden to analyze the data before you know if you can use it. To me, the promise of big data is real-time and predictive personalized services. So data-driven service innovation. And I think that in service and development, it helps that the tests or audits are based on interest instead of purpose specification, because I can relate interest to the customer goal I have and the customer journey I have with the service. In the meanwhile, I still see pirate islands. I still see a lot of companies not able to comply just because their IT systems are a mess. If you ask them, give me your customer information, maybe half of them can honestly say, I know where it is. And then you talk large corporations. If you talk small, medium enterprises, what is about 80% of the business in Europe, they don't even know about this legislation, what's going on. The adaptation of the IT systems to adapt to the legislation are so expensive that you should think about who has to pay the bill. That doesn't mean that I see anybody that I spoke to, about 1,000 companies I spoke to, that they do not want to comply. And all they realize is that you have to combine ethics and morality, that you had to educate risk-savvy consumers, that you have to invest in all kinds of technologies, that data science can find biases and follow automatic decisions. And these new technologies are there, like model-based machine learning, where you model a graph and the logic about it, so you can follow the decisions, but also smart visualizations of correlation engines. And in the end, law of regulation, that's also needed, but I'm not very knowledgeable on that. And I think that the leaving purpose specification in going to more interest-oriented audits helps me to combine better understanding with service development and law. So that's... Okay.
Thanks, Eric.
Yeah.
Maybe Omer, you react and then Anna?
Yes,
yeah, that would be absolutely.
Yeah, so first of all, I want to congratulate you, Lokke, on this piece of literature, which is substantial, and I think you got your PhD based on it, or an adjacent work, so congratulations for that. It's very impressive. The question I'm supposed to answer is whether a purpose limitation principle is outdated and maybe can be replaced by something interest-based. I don't think it's outdated. I think purpose limitation is challenged by the current big data reality and in specific vectors, and I think maybe specifically for regulating researchers' access to data after the fact, to what some people call administrative data of government organizations or municipalities or companies for use for socially beneficial purposes like healthcare or tracking epidemics and stuff like that. So I think that's where it's challenged. I see, the logic in your proposal, Lokke, to replace some of the prescriptive rules such as purpose limitation and consent, which we know has its own challenges, with something like a legitimate interest test, which essentially is a cost-benefit analysis. You have to weigh these interests against the other interests and decide what comes, what carries the day. And this type of rule of reason or reasonableness approach does exist in certain areas of law. The law of torts, for example, the tort of negligence, is based on precisely this type of cost-benefit analysis, and it works. But I think it works in particular in common law settings where courts sort of develop the rules from case to case and the doctrine emerges. I think it's more difficult to implement in a more, civil law continental approach, and I'm not sure how that would work. I want to just finish by advocating maybe for continuing to respect purpose limitation, at least as a data minimization principle. Yeah. Because there is a lot of discussion in privacy and data protection policy circles between the two paradigms of regulating collection or regulating use. I think if we just regulate use, then the horses are out of the stable, and protection for individuals is greatly discounted. So I think there should still be collection limitations, and one of them is purpose limitation insofar as that you only collect data that you actually need, because otherwise it's like collect everything and maybe we'll use it sometime in the future, which I think frankly makes for bad science, first of all, and certainly bad human rights.
Yeah. No, I totally agree. Anna.
Yes.
Is this the...
Thank you.
Yeah.
Does that work? So,
yeah.
I join Omer in thanking you, first of all, congratulating you on this great provocative piece of out-of-the-box thinking and analysis. I think nothing better to help us crystallize our own views and positions. I think I share many elements of your diagnosis of the issues with the current system. But I'm not sure I fully agree with your proposed solutions. And I also, well, probably coming from a data protection authority, this is not really a shocking statement. I read many of your justified criticism of the existing system rather as a criticism of lack of sufficient adequate enforcement or uneven enforcement, complexity, which is fair enough. And I do have some sympathy for the plight of business who realize that compliance will come at a cost. But at the same time, this is not unique to data protection rules, obviously. Compliance with, tax rules can be very complex and daunting. And I don't think that the argument, oh, I wasn't aware of that and it's too complex for me to comply, is really convincing. So I think we should be careful not to apply, a lower standard to data protection. And I don't want to go in as I said, here we agreed to talk about the future. I think personally that and a shift away from purpose limitation in European data protection is certainly a matter for a rather distant future. For the time being, we have it not only in the GDPR, which has not even become fully applicable yet, but it's also in the Charter. I see that it's also taken, it's already in the Convention 108 already now, but it's taken on board in the revised version as well. I saw that the Council of Europe has just released its guidance on big data specifically, where the whole idea is based on this principle as well. So it's not going away anytime soon. But that's all I wanted to say about that. And just to finish, I think that we need to be careful not to paint too dark a picture of the current rules. Because it's not entirely true to say that purpose limitation prevents you from using the data in the future for a different purpose. Already under the current framework, there is the possibility for further use, provided that the new purpose is not incompatible. So it's quite a low threshold, basically. You don't even have to prove that it's compatible. It's enough to prove that it's not incompatible. And we will, I think, come a bit later to the question to what extent this becomes even easier in the GDPR. So I'll leave it at that.
Dennis, yeah, sure. If I can just respond briefly to Omer and Anna. I don't think it's just a lack of enforcement. With predictive analytics, when it comes to predictive analytics and the Internet of Things, you can't know what the purpose is until the data speaks, right? You can't know in advance what purpose you're going to get from analyzing this data. And so you cannot notify people as to that purpose, and you cannot practically get consent. So I do think that there's a fundamental problem with notice and consent and purpose limitation for data analytics and for IoT. So I think if we limit ourselves to those areas, I'm not saying this should replace or could replace data protection regulation or privacy regulation in the states altogether, or that it should. But with respect to predictive analytics and IoT, I do think that there's a fundamental problem of fit between the current system and these new ways of analyzing and collecting data. And an alternative is needed, and I think the legitimate interest test is an interesting proposal in that regard.
Thanks, Dennis.
Yes, only a comment, because you have mentioned the recent adopted text of the Convention the guideline on big data based on the Convention 108. We further discuss this in a panel next Friday at the Cpdp. But I think that also in this guidelines, the focus was based on the idea to maintain, because in the convention, the modernized test, there is this focus on the purpose. But at the same time, we try also to adopt an approach more focused on a broader idea of risk assessment. And in this broader idea of risk assessment, there is also the idea that some information can use for different purpose. In the guidelines, is specifically mentioned the idea that in the big data context, is this kind of reuse, frequent reuse of information. So we have tried to mix the traditional approach and try to give a broader interpretation, because also in the context of the Council of Europe, many parties were aware of the criticism related to the fact that it's a bit difficult to predict the specific purpose of the data collection, because we remember that the text is the specific purpose. Specified. Yeah, specified, okay. Specified. Yeah, sorry. Okay, so the problem is that the specified purpose is difficult to describe, and the risk is that can be described in two ways, or in a very general way, and so it's not useful for the data subject, or in a too detailed way, and there is a lot of literature that show that user don't take into account and click OK. So we have to reflect. There are two aspects. One aspect is the limit of the purpose approach in the context of big data and transformative use of data. And the second aspect is the limits of the notice and consent as a model in front of a complexity of system in which the user are not aware in many cases, or if they spend time, but only a very, very limited number of people spend time in reading the notice, are not able to understand. So this is a problem that we have. Although we remain based both in the convention and in GDPR on the traditional paradigm, this is a problem that we have to address, because this is the main issue.
Well, two comments. I fully agree with Omer. You know, data minimization should be there, but in my opinion, it would be then tied in with a legitimate interest rather than the purpose. Do you see? So that is one. About the common law systems being more suited for development of rules in court cases, I disagree. I mean, we've seen, for instance, the rules on misleading advertising being issued, and everybody said, well, what is misleading advertising? What is a legitimate interest? And I know that the legal department had a totally different opinion about what is a legitimate or misleading advertising than the marketeers. It crystallized in case law, in guidance, and we're at the beginning of the curve, and that always is difficult. What I don't like about the current setup, also of the further processing, is that in the end it is always allowed if you get consent. And actually, if I look at companies, consent is the easy way out. It's like our laws have become a kind of what we in the paper call proceduralism, mechanical procedures where you inform and get consent and then you're done. If you have misleading advertising, it is not allowed, even if you ask consent. And I think all the guidance should be directed at, okay, here you may have a legitimate interest, but here is the red tape, and then you don't have a legitimate interest. And guess what? You can't ask consent. That is, I think, where we need far more clarity and guidance, so you don't have such a big gray area where a lot of companies take Okay, second point. Anna, can I think... Oh, sorry, first a new... Do you agree that consent is currently an empty shell, or what is your opinion on that?
I will surprise you all now. No, not really. I'm sorry. Again, fair enough. I think you point out to a very serious problem that consent might be used by controllers in cases where it shouldn't be used, where it becomes almost abusive because they feel they can legitimize almost anything by asking consent. There is... Well, it's a bit of a specific issue, but we've seen with cookies and banners and such, the notification and click fatigue. So there are good arguments to say, there is a problem. However, to me, again, these are not issues related to the fundamental principle, that a person should be able to consent to the use of their data, but rather how this is implemented and applied and enforced in practice. And I mean, Working Party 29, you obviously are aware that they have identified many of these issues in a number of their documents already years ago, and indicated that consent should not be used where there is another legal basis available. And consent, according to the law, should be specific, informed, and freely given. So by definition, it is not appropriate for very many situations. And I would argue that we should maybe give this consent element a bit more time and a chance for the GDPR to maybe address some of those shortcomings, some of those issues. Because as you note in your paper, consent is still present, and there are some explicit conditions, guarantees, which should, in my view, remedy many of the problems which maybe we observe in practice today. And just to maybe address a more fundamental issue which you raised in your paper about the very place of consent in the scheme for data protection. Okay. I think this is where we absolutely agree, and the EDPS in particular, many data protection authorities have argued for a long time now that indeed consent is not the only, and maybe not even the predominant, the most appropriate legal basis for data processing in very many situations. Just to take an example of the public sector, so the regulation 45/2001, which is basically a copy of the current data protection directive for the EU institutions and bodies, there is consent, but it is actually at the end, almost at the bottom of the list of available legal bases, and in our supervisory practice, it plays almost no role. Now, whether such an approach could have been taken on the occasion of the GDPR, theoretically, if collectively it was felt that this is a good solution, maybe. Legally and practically, I have again my doubts, because whether we like it or not, again, we have the Charter, which refers to consent or other available legal basis. So there is a certain visibility starting point. Yeah. And then the inevitable truth that for certain legal systems, in particular, consent and the principle of informational self-determination is really the core of how they construct the right to data protection and privacy in their national legal systems. So this is something which is difficult to get around at this stage. But I would say let's wait and see and give the GDPR with its new conditions and safeguards a chance.
Okay. In the interest of time, I think we'll maybe, Alessandro, you will comment on the last point. The solution of the GDPR is to strengthen the consent requirements, and instead of making it less prominent. I mean, I see the guidance of the Working Party really working that way, but the GDPR still stresses it like that. Do you think that will bring the required result? Can we solve this by having more guidance of the EDPS, of the Working Party on how to do it?
I think that that's a theoretical position. I think that the consent is traditionally very important, because this is a fundamental right, and so the self-determination is important and is based traditionally on the idea of the consent. But at the same time, we have to reflect also on the nature of this consent. And so the nature of this consent, I think that should induce us to shift the attention from the self-determination based on reading the notice and express the consent towards the risk assessment. So in my opinion, there is a connection between these two aspects. If I am aware of the risk, I can provide a consent that is based on the real knowledge of the risk in providing my information. So the meaningful consent, so-called, is not based on a long list of information, but is based on the way in which I am able to understand the negative impact. In this sense, I think that the risk assessment and the consent awareness of the use of data are connected. Unfortunately, in the GDPR, these two moments are not linked, and the result of the assessment are not public, for instance. In this sense, for instance, in the guideline of the Council of Europe, we adopt a different approach, and we try to put together these two aspects, because we are convinced that if the people are aware of the risk, are able to understand the risk, this is the real moment in which they are able to decide if they want or not to provide the information. not based on a general description. So I think that if we want to maintain the consent, and for a minimum level we have to maintain this idea, because if we refuse the idea to have the consent, it means that companies, government can collect everything without any control. But at the same time, this consent should be combined with an effective assessment and transparent assessment.
May I react on that? Is that I have very much difficulties with the abstraction of this because I'm not a lawyer, but to me I was thinking of, okay, I agree that in current situation it's an illusion that the consumer has influence on the data sets that's flowing around. And I agree with that suggestion from Lokke. But then again, when I'm developing a service, I want to make sure that my consumer wants that service. And privacy issues are part of that. So I look for what mechanisms can I do to make sure that he chooses the right service for him or for her. And to me, to link that service and do that at the moment that the service is delivered, because then I can explain what the risks the customer has, and I can also explain in layman terms what roughly the deal is and what the business behind that is. So I have really difficult in the abstract discussion about consent and risk analysis. I think on the other hand, the consumer should be in mechanism term know if you do a service from Google, you know what their business model is. They earn money with advertisement, and they do a lot of search stuff. And if they change their business model, you're at risk without knowing all the details of a ranking algorithm. So, and at the moment that you do search, you should know that. And for all different services, the same thing. So very tough for me, this discussion about...
Thanks, Eric. Yeah, Omer, can you...
Yeah,
do you want to comment? Yeah?
Yeah, just a small comment about consent. I think, like Alessandro said, in a framework and a system that is grounded, the bedrock for privacy and data protection is human dignity and autonomy and individual choice. Yeah, you just can't take consent out of it. And I think you would agree, Lokke, that it doesn't make sense to determine areas where even processing with consent is illegal, because even the most egregious privacy violations, I think, are legitimized by consent. People agree to be in a Big Brother house, like on television, or to share their medical data on patients like me, a website for people who have severe illnesses. And I think it is legitimate if it's real, informed, and voluntary consent. I think we have to recognize that people's choices are oftentimes not informed or irrational. I mean, you saw the results of the US elections, and that applies across the board in law, and contracts, and in many other contexts.
Thanks, Omer. I think we can go to what the proposal is. For instance, to start with, the legitimate interest would apply also to collection. And also data minimization would apply there as well as part of the legitimate interest test. So that is one. I'm not in favor of never consent. There are very valid situations where you can ask consent. Where I think things go wrong is that we and then we had another panel where I made this point. Our starting point of our legislation, and in certain countries even more, it's like autonomy, full choice, and that is when we have the best legal protection and system, because everybody is totally in control of what they want, and they are the ones best deciding on what happens. And then you have Cass Sunstein, who does a lot of, is a perfect book, The Ethics of Influence. And his statement is, yes, that is a great starting point, but autonomy is actually in some cases best served if you take away certain choices, if the choices are so difficult for people to make that they actually like to delegate it to somebody else. I don't need to know what is under the hood of my car. I want to know the car is safe. It will take me too much time and effort. I want to focus on the things that really matter. And if I translate this in a clear example, let's take the cookie legislation again, because everybody recognizes it as, you know, not functioning. I think we can agree there. I can imagine that the EDPS or the Working Party says, okay, if you do it in a proper way, on a website, you tune the content, you do advertising tuned to me, but you keep the data within your company and just use it to improve the services, as Eric says, and to really add value to me. Maybe if you secure properly and have all the and don't do ridiculous things and don't buy loads of data that you don't know about. I mean, there's all mitigating measures around it. That, you know, you could have a legitimate interest and you don't have to ask consent for this. Then the social media company can actually make money with advertising, but you can have an opt-out, so people who really are privacy-minded can get out of that system. Then you can at least make money. But do they need to make money with cost-side advertising, with a whole advertising network, with, I mean, that is where I think a lot of people really resist. Maybe that is time to ask an opt-in, but then a big button, yes, I want to be tracked. My guess is not that many people will click that button. By giving them consent rights also for the stuff happening in the site, on the site themselves, or on the site itself, you give them so many rights that they don't make a choice anymore. And maybe in that case, it is actually increasing autonomy by taking the hot potato away and say, okay, here it is a legitimate interest based on these mitigating measures. Here you need to have consent. But, you know, and then it's real consent. And I agree with you on the GDPR, that system should work out. But, you know, the fact is that there's so many incentives now for companies to try to combine, to do this. We need more clear guidance where it stops and you need the consent. But then if you put that bar too low, and that is the real point of my paper, if you put the bar too low and you need consent for everything because we're so in favor of autonomy, you end up with a lack of autonomy. And that is, I think there's a lot of, in the book of Ethics of Influence, I thought it was brilliant. Yeah. Okay. I think it is time to move. How much time do we have left?
10 minutes to 5 and 15 minutes for 20.
So we still have time for...
we have to leave the room at the end here.
Okay. So, Omer, do you want to comment on this one? Do you see limitations, benefits? I mean, you said limitation is...
Yeah, so I think legitimate interest is an important part of the framework, and you see this in the US also with the unfairness test that the FTC applies. There's a three-part test that was articulated by the FTC 20 or 30 years ago, and it requires assessing benefits against costs to consumers. So I think, you know, it's, in a way it's a global standard and it's always been there. I just think that it has to be augmented by
other elements. I totally agree.
Yeah.
Maybe this is a perfect moment for you to... yeah.
If you could go to my first slide.
Yeah, I'm trying to look.
Okay.
Yeah.
Keep going. Yeah. Okay.
Thanks.
So this is the provision that Omer just mentioned, Section 5 of the FTC Act. And so the question for me here was, is there potential for common ground between legitimate interest tests that Lokke and Corinne have proposed and US law. And I'm specifically focused on data analytics and the Internet of Things here. And I think that there is a potential for common ground. And that the area of US law that could work quite similarly is the FTC's unfairness authority. And this is in Section 5. And as Omer said, Congress has defined what unfairness means with respect to unfair business practices and behaviors, including business practices involving predictive analytics and the Internet of Things. And it defined unfair according to 3 prongs. There has to be a substantial injury to consumers that is not avoidable by the consumers themselves. I mean, if it were practical to make all these consents and make all these choices, then maybe it would be avoidable, but I'm not convinced that it is. And third, where the substantial injuries are not outweighed by countervailing benefits to consumers or to business. So it's that third prong that has the balancing test. And courts and the FTC have interpreted it, in fact, in other contexts, because this authority reaches much more broadly than just data. They've interpreted it as requiring a cost-benefit balancing test. On the one side, you weigh the substantial injury to consumers, and on the other, you weigh the interests of, in our case, the data controller, and also the public interest, the society at large. And there's a balancing there to see whether this practice is fair or unfair. And here, I think, is where we see a strong similarity to the legitimate interest test. Because these factors are very similar to the ones that the Article 29 Working Party has identified as being important to the balancing that goes on in legitimate interests. And so the Article 29 Working Party says, consider the impact on data subjects, including on fundamental rights. That's very similar to the substantial injury. Consider the interests of the controller, and consider the public interest. And those are the elements of the balancing, quite similar to unfairness authority in the US. So I think these two tests are quite similar. I also think that they face a very similar challenge. And the challenge is this: if the regulator is to balance the interests between the consumer, the data subject, the controller, and the public, how should it go about doing so? What standard should it use? Should the regulator use her own personal view of how these different interests weigh against each other? Well, that doesn't seem quite right. In a democracy where the regulator is not directly elected or accountable to the people, it doesn't seem that those fundamental value decisions should be made in that way. Okay, so what standard then? How do we come up with a democratically legitimate way of weighing these trade-offs beyond what one individual or one particular group or one ethicist or group of ethicists think is ethical and, you know, comports with good values? And I think that is the question that's at the heart of this new paradigm, of any paradigm that would look at engaging substantively in terms of the interests that are affected by predictive analytics and the Internet of Things, moving away from the mechanical proceduralism to actual substantive analysis. You have to say, well, whose values count here? And I think that this Section 5N actually points a way to a solution to that difficult question, where it says, in determining whether an act or practice is unfair, the Commission may consider established public policies as evidence to be considered with all other evidence. And I think this is really interesting. Congress is saying, look, commissioners of the FTC, don't just use your own judgment, your personal view of what's ethical and what's not, where the balance is and you know, what's fair and what's not. Instead, look at the established public policies that legislation and the regulations and court decisions that interpret legislation have adopted. And let those values, the values expressed in the law, the established public policies, guide your unfairness decisions. And I think that's very helpful, because it would give the commissioners a point of reference to ground their unfairness decisions, and I'll finish very briefly in a second, and that framework would come from their democratically elected representatives, and so would be much more legitimate in a democracy than just the commissioner's own subjective views. And as I read it, and this is the next slide, and then I'll finish, the Working Party 29's analysis of legitimate interest points, or could be read to point, in a similar direction, where it says the key factor should be whether the action is otherwise in the public interest or benefits from social culture or other legal or regulatory recognition. So there too, perhaps, they're pointing to look to established values created by democratically elected legislators. So I think both the approaches between unfairness, and I have to say FTC has not really adopted this for privacy yet. They have for security, but they could for privacy with respect to predictive analytics. There's a similarity of correspondence, and not only that, and so you could have a transatlantic system for handling these issues that is internally consistent, and not only internally consistent, also democratically legitimate.
Can I jump in
sure,
here for a second?
Omer.
So I actually, hearing Dennis talk, I wanted to mention another framework which isn't legal but is ethical, that also places this cost-benefit analysis at the center, and it's the Belmont principles for human subject research. So these are principles that were set forth in the US in 1979 for experiments on human subjects. And there are 3 principles which were later in 1991, I believe, adopted by the US federal government as what's referred to as the Common Rule, which was actually just updated last week. And the 3 principles are respect for persons, beneficence, and justice. So respect for persons usually involves informed consent, much like the data protection framework. Beneficence is the cost-benefit analysis. You have to make sure that the benefits of the clinical trial, for example, outweigh the costs. And justice depends on distributive questions, who benefits and who loses, which are important questions in any cost-benefit analysis, and I think Dennis was alluding to that. Just to say that the decision maker in that context is an IRB, an institutional review board, which has to include different stakeholders, and maybe that's something that should be emulated outside of academic institutions and in companies or government departments. I also have to say that I want to apologize. I'll have to leave a couple of minutes early because I moderate a session in the next room at 5:15, so apologies for that.
Don't worry, don't worry. Anna, do you want to have I know you have something to say on the sensitive or the special categories of data.
We haven't touched that, so I don't.
I'm quite happy if you have some comments there to take them. I think we have time.
Well, if that's okay.
Yeah,
want to make
absolutely.
an introduction first, because so basically, if I understand your argument correctly, you say that the system is obsolete. I mean, the system distinction between sensitive data and other data, and
well, I think it's not obsolete in the sense that it is relevant. I mean, for sure, there's certain categories of data that are really sensitive, and I think that would be one of the big elements in the assessment, whether there's a legitimate interest to process it. But then you can take along all the mitigation measures rather than a kind of binary decision. This is sensitive, and these are the grounds you can process it on without, it's so contextual. I get the point that there's certain categories where there's maybe a minimum level of protection, but I find there's so many cases where I would say, why is if you consider this sensitive, then this is equally sensitive. Why is the test, for instance, the legitimate interest test, totally fine to apply it there and is supposed to give sufficient protection? And why is there specific legal grounds that I find, actually less protective? Do you see? And I know the Working Party put in extra safeguards, etc. It just makes it so complicated. Well, that is my point.
Okay, now I have to thank you. So I think on a very technical level, I'm not sure I fully share your analysis, because I think what you do not mention is that basically in the current system, in the GDPR, the principle for special categories of data is a prohibition, unless a certain derogation is applicable because it was considered by the legislator that, there is a prevailing interest. But basically your argument about removing these extra protections for sensitive data also made me think about, how this framework could apply, or what would be its future scope. Because I think you mention somewhere in your paper that it would not be entirely suitable to regulate government data processing or public sector. Or would it? So for me, in the current climate in particular, the combination of changing the paradigm from purpose limitation to something else, removing the prohibition, for all practical purposes, the prohibition on processing of sensitive data, and applying all that, for instance, only to predictive analytics by state agencies. This is like the, nuclear option. So I wonder whether you basically have any thoughts on how this that could actually, work in practice?
Okay. Well, I find that the state should be very predictable. And I think, they can process data based on the legitimate interest. It's in the GDPR stating that they cannot. They cannot. And I actually agree with them, but for all purposes, I think there should be a legitimate interest, and which is then codified with all the safeguards in the law. That is what my position is, and which is actually basically what, how the GDPR is set up now, with which I agree. Another thing is that the paper, our task was to write only for the private sector because others were writing on the public sector. So that was a very practical thing. But the bottom line is that you can't, just to say to the government, okay, you have the legitimate interest ground without, a democratic review and putting that down, given their position or how and their powers, I find that given what I know of some governments and what they do, I think they take far too much leeway. It must be very predictable. That is my personal opinion. Does that help, or?
Yes, I just think that that this is really an important issue if we want to be serious about discussing possible alternatives, for the medium to long term future. What exactly would it be that we would apply it to? And also I'd follow up with the question, do you think that it's feasible? So far, basically, imperfect as it may seem, we have a similar or the same set of rules for the private and public, with exceptions which result from either established practice or because there are laws for some things and not for others, and legitimate interest limitations with respect to the public sector. The same for consent, because there would normally not be a free consent because of the position of imbalance, etc. But that brings me to my question again. To what extent it would be feasible to apply your new regime to the public sector and the state in the future, or else do you see that it would work to have two different systems, knowing that actually the boundaries are not so easy always to set because of public-private partnerships, outsourcing to private actors, and obviously the fact that we've seen that governments have relatively easy access to quite a lot of data gathered by private companies when they want to. So to me, it's just a question to explore.
Yes, and we can also add a provocation from the opposite perspectives. So the idea that, sorry for my voice. So the idea that in your paper you move from the idea that the sensitive or specific category of data protection of data is not so relevant in this context, but we can also say that it's not relevant because also non-sensitive data are sensitive data in many cases. So it's true also the opposite perspective. So there's a criticism in this distinction between sensitive and non-sensitive, because in the past, before analytics, was possible to distinguish between sensitive and non-sensitive. Now, if you collect mobility information, you know that a person go to a church and you can extract a sensitive information based on the mobility pattern. So, and you can do in many cases also if the pattern are partial anonymized or pseudo-anonymized and so on and so on. So from this perspective, the distinction is not so clear, but not because the sensitive are not sensitive, because the non-sensitive became sensitive in many cases. Yeah.
I think, Alessandro, if I can just push back a bit more on that, I think even before the age of predictive analytics, the concept of sensitive data was a tortured concept because it always was very contextual. So the first case, in the, as it was called then, the ECJ, under the Data Protection Directive, the Lindqvist case, involved a Swedish churchgoer who posted some information about a fellow churchgoer, which was considered sensitive because it was medical, except it was the fact that the other churchgoer had a broken leg, which doesn't strike us as really being sensitive. I think the truth of the matter is that the test for sensitivity is quite similar to the test that one of the Supreme Court justices once gave for defining pornography. I know it when I see it.
Yeah. If I may still, I would just say that fair enough, Lindqvist was special. And yet, we are meeting at a time where, if I'm not mistaken, a number of US tech companies felt compelled to publicly state that they are not planning to build a Muslim registry, maybe not with these words. So, excuse me, but I would still argue that I don't mind a rule which simply says data about religion, race, ethnicity, etc. must not be processed unless the legislator decided that there is a good reason for you to do so. Thank you.
Okay, I think we need to... Thank you all. We're a bit early, but then you can all go to your next panels. If there is a really urgent comment or question, yes, go ahead. Just speak out loudly without a mic. Yeah. If you're an artist, you can do it purposeless. If you're earning money, you yeah. Maybe your point is clear, Dennis.
Okay,
a
so
short answer.
Here's my take. Yeah. Maybe this is a U.S. perspective.
Louder.
That the idea of privacy, as set out in the 1960s, was privacy as control over your personal data. And I understand there's other views of privacy, human dignity, other things, but I think this is very important to the purpose limitation. So you get to control who collects and consent to how it's used, the purpose for which it is used. That's control. If it can now be used for other purposes without your additional consent, you've lost control. So to me, that's the logic of how notice, consent, and purpose limitation fit together, and they're all based around giving the individual control over her personal data, and that is one definition of privacy.
And if I may add, it's also consistent with the European framework in which data protection is part of fundamental rights, and when there are personality rights, the person should be in the position to provide or not the consent about the use of these rights. So it's consistent also with our... So the conclusion at the end of the panel is very difficult because there are a lot of those on the table and also different kind of approach. And that I think is important because, as I mentioned before, this is the Jure Condendo. So thinking about the right is not about some specific provision, but I think that this debate is useful also for legislators, lawmakers, because as we know, and also is the outcome of this panel, the system doesn't work so well. There are some problems. And we start now this kind of debate, and we probably continue in the next few years, because we have to solve this kind of criticism. Because if we don't solve this criticism from academia, from regulator, the risk is that is solved by the market only, and that's not necessarily the best solution in my perspective. Thank you.
Thank you all very much for coming.